Okay, everyone. So, welcome back. Hopefully, everyone can hear me and see me okay. Today's lecture will deal with jury decision making. It's a pretty quick lecture, at least compared to some of the other ones that we've done that have gone on for 2 hours or longer. So hopefully, I'll be able to keep it short. By not going on too many rants here. But when we talk about jury decision making, this is a subset of, say, the area within psychology and law in general known as legal decision making. So essentially, how are people reaching decisions when it comes to these legal matters? You have to think, when we're talking about law, we're not using the same principles that, say, are used in science. Sometimes they're not even really logical or even common sense. There's a whole bunch of laws out there that really don't make any sense. Prohibition of cannabis being one of them, right? Plenty of others. So also within the domain of law, people, particularly the triers of fact, which are usually the jurors, sometimes the judge, are presented with complex and often contradictory information. So how do they weigh this information? How do they evaluate this information to ultimately reach a judgment, to reach a verdict? Well, let's take a look at some of the different models and some of what the research says here. If I can move this over a bit. So some of the questions that we kind of spelled out here. How do juries decide, or jurors, if we're talking about the individual, how do they decide on a quote-unquote appropriate verdict, right? How do they reach this verdict? And how willing and able and motivated are they to process this large volume of trial evidence? And like we said, some of it, not just some of it, but most of it being contradictory in nature. We'll see in this class, there's going to be a ton of evidence. Most of it is contradictory. And this is just a mock trial. This is just a class assignment. So you can imagine a trial that goes on for days or weeks or months, sometimes over a year, right? Are jurors really motivated to pay attention and to process this information? Are they able to do that, even if they're motivated, if they really would like to do that? Can their brains actually do it, right? Also, how do they assess and combine disparate sources of information? So how are they assessing and then combining information that doesn't match up, that contradicts each other? So these are important questions, and if we take a look at them, these are cognitive questions, right? This is pure cognitive psychology, decision making, being applied to the legal system here. Another question: by what process do they, meaning jurors, evaluate and use the trial evidence in reaching their decisions? So we can take a look at a couple of different, say, models here. We know, in general, no matter which approach that we're taking, we know that jurors' decisions involve a complex and a nuanced set of cognitive processes that transform difficult choices into easier ones by amplifying one alternative perspective on the evidence and deflating competing perspectives. So what does this mean in real people language? Well, that juror decisions involve complex and nuanced cognitive processes that take this very difficult information and difficult choices and transform them into one particular choice that they will kind of stick with, and kind of deflate competing choices, right? So jurors are presented with a whole bunch of complex information. They will try to make sense of this by creating, or let's say, creating a perspective that fits that evidence, or in which that evidence fits, and kind of ignoring or downplaying alternatives to that type of, or to that perspective, right? So essentially, they're engaging in confirmation bias. They're going to stick with a quote-unquote story, and accept the evidence that supports it, and ignore the evidence that doesn't support it, right? But let's not use the term story quite yet. Let's say perspective, because we'll see in a minute that the term story in regard to jury decision making is a very particular type of term. So there are various cognitive factors that can affect jurors' abilities to process complex and lengthy trial information, and can affect their ability to make judgments. Two really easy ones that come right off the top of my head would be a participant's, or in this case a juror's, willingness and their ableness, right? So are jurors willing to process this complex and lengthy information? And are they able to process this complex and lengthy information? So those are two different things. Somebody might be very willing. They might have the best of intentions, right? They want to be a good juror. They want to do their civic duty. They want to make sure they make the right decision, that they reach the right verdict. But their cognitive capacity just isn't there. On the other hand, you might have someone who has very strong or very high cognitive capacity, but their willingness to pay attention or to participate just isn't there, right? They're bored. They're not interested. So there's a host of other factors that can affect jurors' abilities to process trial evidence, but those two, willingness and ableness, would definitely be two of the main factors, and we'll see that come up again later in the semester. So a couple of models that try to describe jury decision making. Some of these models that describe this type of process that jurors are going through tend to fall into one of two categories. So mathematical approaches and explanation-based approaches. So most of the jury decision-making theories that have been put forth can be classified in one of these two ways. Jurors are either taking a mathematical approach, or they're taking an explanation-based approach. Oops, clicked on the wrong one. So let's take a look first at the mathematical models. So there's essentially three different models that exemplify the mathematical approach. The first being probability theory. So jurors are essentially taking a look at the evidence, taking a look at the themes that each side is concocting or putting together, and kind of weighing which one is more likely. Or they're assigning probabilities associated with different outcomes or different likelihoods that are associated with different pieces of evidence. So what is the likelihood that somebody would leave their DNA, in this particular situation? Or what is the likelihood, that this is just a coincidence? So according to these types of theories, jurors are assigning probabilities to different events, and they're kind of weighing those probabilities to determine what is true and what is not true, or rather what is more likely and what is less likely. Another approach might be an algebraic approach, and this is also, this could be thought of as kind of a additive approach. Well, there's two ways, according to these theories, two ways that jurors can process information. Is that it can be an additive approach, so each piece of evidence that is presented, let's say against a juror, against a defendant, that jurors are taking each piece of evidence and adding it up, and the more evidence you have, the more they're convinced that the defendant did it, right? So the more evidence that you add that goes against the defendant, the more likely they are to find the defendant guilty. The other approach to this algebraic theory is that jurors are using they're using an averaging or weighted approach, let's say. So they're going to see, well, during any trial, some evidence is really damning, right? Like, your blood and fingerprints are found on a murder weapon. That's pretty damning evidence. That's really strong evidence, right? But there might also be submitted into evidence, a receipt on your credit card showing that you were at the deli next to the place where the crime took place at the same time that the crime took place. That's less damning evidence, right? It's still strong, but it's less strong than DNA and fingerprints. So according to, say, an averaging model, what jurors are going to do is they're going to take that really strong evidence and they're going to take that weaker evidence and they're going to average it and kind of meet somewhere in the middle. So according to these types of models, what you might not want to present all of your evidence against a juror. You might not want to throw against a defendant, right? You might not want to throw everything you got at the jury. Why? Because they're going to see some really strong evidence and they're going to see some really weak evidence, and then they're going to meet somewhere in the middle. But what happens if you only present your strong evidence, or let's say you only present your medium to strong evidence? Then they're going to average in the middle there, right? So right here they were averaging between weak and strong. Here they're averaging between moderate and strong. So according to these types of models, sometimes it's actually detrimental to present every piece of evidence you got against the defendant, because the jury is going to average the evidence and you're going to end up somewhere in the middle. So it's best to only present your strongest type of evidence, and so your moderate to strong type of evidence. So the average will be higher in terms of guilt, right? And then some other approaches fall into this stochastic processes type of approach. Sorry, here, just got a reminder that I got some software to update. And I put in there probabilistic, but that sounds a little too similar to, say, probability theory, the first one. These types of approaches take into account random or chance factors. So according to these, let's say this type of model, or the models that fall into this category, jurors are going to basically evaluate, well, how much of this is coincidence, or can coincidence or just chance or random factors explain what's going on. Not necessarily that the person is guilty or not, but maybe they were in the wrong place at the wrong time. That type of thinking in there. So in all three of these models, jurors are thought to engage in a series of mental calculations in which they weigh the relevancy and the strength of each independent piece of trial evidence and translate the resulting score into an assessment of the defendant's culpability. Okay? Think about that, and think about how humans typically make decisions. Okay, well, according to all of these theories, all of these mathematical theories, jurors are evaluating each piece of evidence carefully. They're assigning a certain weight or score to each piece of evidence. All of this is going to come together into a grand assessment of a defendant's guilt, right? Their culpability. This score is then going to be compared to the criterion needed to find the defendant guilty, which is beyond reasonable doubt for a criminal case, or a preponderance of the evidence for a civil case. But those of you who've taken cognitive psychology, those of you who've taken social psychology, particularly with me, know that this is not typically how humans make decisions, right? We tend to be cognitively lazy. The brain is built for efficiency, not accuracy. So this idea that that jurors would be weighing every piece of evidence is kind of absurd when you really think about it. If you truly understand how humans operate in terms of making decisions, it would be impossible for a juror, a single juror, to even keep track of every piece of information, let alone what score they ascribe to it. We rely very heavily on heuristics, on mental shortcuts. So these mathematical models, I don't think so. It's typically not how humans operate. That's a lot of cognitive energy that has to go into that type of decision making. Not everyone's able or willing to do that, right? So luckily we have some other models here, the explanation-based models. So of these, the most important, or the one that we'll focus on the most, is the story model. And this was developed by Pennington and Hastie. And it states that jurors construct a narrative storyline out of the evidence presented during the trial. So they're listening to the evidence and they're creating a story of what happened, right? Not just what happened, but also why did it happen. So they're not looking at every individual piece of evidence and giving it a score or a weight. Instead, they're taking a look at all the evidence and creating a story or a narrative out of it. Now, ultimately, whichever story the defendant's or the defense or the prosecution's story, whichever one is more convincing, and whichever one does a better job at explaining the evidence, that's the story that the jurors are going to go with, right? So in this type of story-based approach, or this model, there are three stages. The first is evaluating the evidence through story construction. Now, this is where opening statements from the defense and the prosecution can be really important, because opening statements themselves they're not evidence. So jurors can't use them, opening statements and closing statements. They can't use either of those in terms of reaching a decision per se, right? It's not evidence, so they can't consider these statements while making a verdict, guilty or not guilty. But it is the first time that a prosecutor or defense attorney gets to kind of quote-unquote prime the juror. They are able to say, this is what happened, this is what the evidence is going to show. They basically get to lay out their version of what happened. They basically get to tell the jury a little story, right? And how the evidence that we're going to present is going to support this story. So opening statements in that sense can be very important, because they're going to help jurors build this story. So jurors are going to create a story as they go along, according to these types of models. And as new evidence is presented, they will incorporate it into their stories. So if you're the defense, you definitely want jurors to have a story where you didn't do it, right? And if you're the prosecutor, you definitely want the jury to be constructing a story where the defendant most certainly did do it, right? So the first is evaluating the evidence by creating a story of what happened. Number two, learning about the various verdict options that are available. So guilty and not guilty are, the two big ones for criminal cases, or liable, not liable for civil cases. But we already spoke about different types of insanity defenses, or guilty but mentally impaired defenses. So there are definitely other verdict options available. And also, sometimes a person being tried for murder, jurors might be able to find that person guilty of manslaughter instead, which is a lesser charge. So after jurors will construct this story based on the evidence, they'll learn about the various verdict options that are available to them. And then the third stage involves reaching a decision, reaching a verdict, essentially, by fitting the story that they constructed to the most appropriate verdict option. Again, that'll usually be guilty or not guilty, but not always. Sometimes there are other options available. Okay, so during the story construction stage, jurors use three kinds of information to create a plausible story, or to create the most likely story, let's say. The first is the evidence presented through the trial. So this is essentially the testimony that comes from witnesses that are being called by the defense and the prosecution. Jurors will also use their real-world knowledge of similar cases or similar crimes that happened in their community. So jurors are not blank slates. They come in with certain experiences. They come in with certain information, certain knowledge, and that is going to play a role in their decision, ultimately in the decision that they reach. And number 3, their own generic expectations and experiences relevant to the issues in the case. So when we say generic expectations and realizations, these are not specific to the case in hand. These are just people might come into let's say come into the trial with a generic distrust of authority figures, let's say, based on their prior experiences. So they might be more inclined to side with the defense. Or people might come in with a generic type of disposition to trust police officers because they come from a family that's full of police officers. They come from a law enforcement family, right? So these type of generic expectations and experiences can also affect their the verdict that they reach. Okay, so various interpretations of the evidence can result in different stories. So again, when it comes to the idea of empiricism, right? We always say empiricism, seeing is believing. Don't take anyone's word for it, see it for yourself. But we often see what we want to see, and we all have our own biases, and they're all different from each other. And you and I can see the same event take place and walk away with two very different interpretations of exactly what happened there. So when it comes to story construction, you might have 12 people on the stand listening to the same evidence, and you might have 12 different stories or story constructions about what actually happened, right? What actually took place. So the juror will ultimately adopt the story that, in his or her mind, best fits the evidence and is most coherent. So according to the story models, we're developing stories based on the evidence that we hear, based on our real-world knowledge about similar cases and about similar crimes that happen in our communities, and based on our generic expectations and prejudices and biases that are relevant to the case somehow. So we'll construct these stories, we'll learn about the different verdict options that are available to us, and then we're going to pick the verdict that we think best fits our story that we constructed. So there's no weighing of the evidence or no mathematical approach in terms of assigning probabilities that, this evidence is more damning than that evidence. Instead, according to these models, we're constructing a story, and evidence is going to fit into that story or it won't, right? If we're presented with, so let's say we're constructing a story and we're presented with a bunch of evidence that somehow discredits the story, well, then we're going to have to change our story, right? Well, we're going to have to adjust it based on this new evidence. But whatever story fits best is the one that we're going to go with, according to this story model. So, what does the research actually show? Well, empirical data show that jurors have a strong inclination to construct stories out of the evidence. So, again, Pennington and Hastie, they did a whole bunch of research on jury decision making, particularly the story model. And they found that when the prosecution used a story-based strategy and the defense did not, jurors convicted the defendant 78% of the time. So this was in one study where the prosecution used a story-based approach. The defense didn't, and the defendant was found guilty 78% of the time. when the strategies were reversed, meaning that the defense used a story-based approach and the prosecution did not, the convictions dropped to only 31%. Same exact evidence presented to these mock jurors, right? It's just how it was presented to them. So we see we basically flipped it, right? Basically flipped those results based on, you know, who was using the story approach and who wasn't. So these findings suggest that the easier it is for jurors to construct a narrative, for them to construct a story, the more likely they are to render a verdict that is consistent with that story and with that narrative. So, you know, it would be wise for prosecutors and defense attorneys to take the story based approach and to try to convince jurors that your story is the better one, is the best one of the two. Okay, so why do jurors construct a guilt-based narrative while others construct a not guilty based story? How do people come to these radically different verdicts based on hearing the same evidence? Well, Pennington and Hastie proposed that the constructive narrative of story generating is based on jurors' prior experiences, their knowledge of the world, and ability to deal with the legal constraints that are placed on them. In other words, we reach these different conclusions, even though, or we construct these different stories, rather, because we have different experiences, we have different world views, we have different knowledge bases, right? We know different things. We also have different levels of being able to deal with what the law requires from us. What do I mean by that? Well, there's the Casey Anthony story or trial case is a really good example of the jury doing the right thing even though they likely did the wrong thing. What do I mean by that? Well, Casey Anthony, for those of you who are not familiar with the case, you know, my opinion, and this is what the prosecution was claiming, is that she killed her daughter. And the daughter was like 4 or 5 years old, a toddler. You know, Casey Anthony wanted to go out partying, stuck with this kid, and Casey Anthony searched the internet how to create chloroform, which is actually really easy to do. You can create chloroform with the stuff in your house right now. But if you Google that, then you're gonna end up on all those lists that I'm on. The government's gonna be keeping an eye on you there. But she did Google how to create that, and there was also chloroform found in the trunk of her car, which is where you know, the body of her child, of her kid, was found, or the evidence showed that you know, there was a decomposing corpse in the back of her car. Now, the prosecution went with murder 1. So, murder in the first degree. That's premeditated murder. So, the prosecution was claiming that Casey Anthony intended and planned to kill her child. The evidence that they presented did not support that story. The evidence that they presented to me, my interpretation of it, and this is exactly what the jury found as well, was that she did not intend to kill her daughter. She absolutely did kill her daughter, but she basically just wanted to knock her daughter out, to make her unconscious so that she could go party. Ultimately, that plan failed, and the kid ended up dying, right? But that's not what the prosecution, that's not the story that the prosecution was saying. They were going for murder one, that this was premeditated. Well, I actually watched that case. It was during the summer. I spent quite a bit of time following it, the actual live trial on Court TV. And I'm like, it's going to be tough to prove premeditation here. So, in the end, Casey Anthony was found not guilty, and she's a free woman, even though she most likely did kill her kid. The jury, when I said that they did the right thing, is they found her not guilty of murder one, because she was likely not guilty of murder one. She likely did not intend to kill her kid, that there was no premeditation. The prosecution overcharged her, right? They should have gone with murder two, which doesn't require premeditation, depending on the state, right? But this, I believe, was in Florida, if I'm not mistaken. So the jury did the right thing, because, yeah, the prosecution didn't make a compelling case that she intended, or that there was premeditation involved. But that has to be really difficult to do, right? When you know that somebody most likely, very most likely, killed their kid, and then you have to let them go, right? You have to find them not guilty. Why? Well, because the law, you have to follow the law. Did the prosecution prove murder one beyond a reasonable doubt? No, they didn't, right? So that's what we mean when we talk about ability to deal with the legal constraints that are placed upon them. So some people are able to deal with those types of constraints, that just being one of many examples. But without getting, too hung up on Casey Anthony there. Each juror has varying degrees of experience with issues related to the facts of a case. And this experience affects how he or she interprets both the trial evidence and the judge's instructions. So essentially, we reach different stories because we're different people who have different lived experiences and different knowledge. We know different things. We will interpret things in different ways. We will perceive things in different ways, including the instructions that are given to us by the judge, which instruct us how we should interpret the information. We might interpret the instructions telling us how to interpret things differently. So we reach different conclusions because we're different people with different knowledge and different experiences. Okay. One issue that causes a bit of a conundrum here, for, let's say, dilemma, is the notion of death qualification. And we'll see how this is related to jury decision making in a moment here. But what is death qualification? Well, death qualified jurors I'm just reading here. Just so cultures in terms of. Okay, so I'll just read this and then I'll explain to you. So death qualified jurors differ from jurors who are not death qualified, so-called excluded jurors, in terms of their willingness to impose the death penalty. But they also differ in terms of their willingness to convict criminal defendants. So let me just explain what death qualification is. So death qualification comes into play when we're dealing with a capital trial, meaning that a defendant, a potential penalty is the death penalty, that they might be facing the death penalty. So during the jury selection process, if this is a capital case and a potential punishment, if this person is found guilty, is the death penalty, you need jurors who are able to sentence somebody to death, right? So that's the law. You need jurors who are able to fulfill the law. So in death penalty cases, you're ending up with a jury who is quote-unquote death qualified, meaning that they don't have any particular opposition to the death penalty. That if they find that this person is guilty, then they have no problem sentencing this person to death. Now, anybody who does not believe in the death penalty, they cannot execute the law, right? No pun intended with the term execute. But if the law says, yeah, no, if this person is guilty, they can face the death penalty. If you are opposed to the death penalty, guess what? You get excluded. You can't serve on that jury. You're not, quote-unquote, death qualified. So death qualification refers to whether people are able to sentence someone to death in a capital case. Now just think about it. It doesn't take a rocket scientist here. People who are opposed to the death penalty versus people who, say, support the death penalty might differ in many different ways. I can think politically, right? That typically tends to be, say, a difference when it comes to the death penalty. Political differences in there. We also know in terms of certain religions, like Catholicism, if you grew up Roman Catholic, like I did, from an Irish or an Italian family, particularly on Long Island, right? The death penalty, nope, no, not gonna happen, right? So people who are death qualified and people who are not death qualified, they differ in a lot of areas, not just in their willingness to sentence somebody to death. And I'm going to show you some research that shows some of the ways that they might differ. So we see Cohen et al. In one study here found that 75% of death-qualified jurors convicted the defendant of homicide in one study, a mock trial, compared to only 53% of excluded jurors. So the jurors who were not death qualified, right, who opposed the death penalty, could not impose the death penalty on a defendant. It was about 50-50 in terms of guilty or not guilty, which is what we would expect. Typically when we do trial research, we try to make the evidence about 50-50 and see if other stuff is making people lean one way or another. So about 50-50 for the excluded jurors, but 75% conviction rate for the death qualified jurors, which suggests that people who are death qualified might be more pro prosecution or more anti-defendant, right? Anti-defense. So we see that death qualified individuals also tend to favor crime control models of criminal justice as opposed to due process models that focus on fair procedures or even on rehabilitation. So people who are death qualified, who can sentence somebody to death, tend to be more, quote-unquote, tough on crime, right? And less concerned about rehabilitation and less concerned about the defendant's rights in terms of due process. So we're seeing some important differences here that might affect a verdict, and not just affect a verdict, but also affect sentencing guidelines, right? So what are some potential, say, reforms or proposed reforms? Well, whatever the reason, an increasing number of judges are experimentally assessing the effects of allowing jurors in the courtroom to ask questions of witnesses and to take notes during trial. This is not exactly related to death qualification, but some of the, I was going to present some of the proposed reforms to this dilemma of death qualification, but we're talking about proposed reforms to let's say jury decision making, it is easier to reach accurate verdicts. When it comes to proposed reforms to death qualification, there really is none. If you are opposed to the death penalty, then you can't possibly assist on a death penalty case, right? It's a conundrum. It's a dilemma. It's an unfortunate one because the people who do support the death penalty or who can sentence someone to death tend to be more, let's say, more law and order. I don't want to use political labels, especially in this time when the country is so divided here, but tend to be more, say, like conservative in terms of how they approach the criminal justice system, right? So they tend to be, more pro-cop, more pro-prosecution, more anti-defendant, more law and order, those types of beliefs, right? Which are not inherent to any political group or ideology per se. I always make a joke, but I'm not joking. I'm only half joking sometimes about the death penalty. Is that I don't support it because the government. I don't trust the government to get it right all the time, and I'd much rather some guilty people not be put to death than to have an innocent person be put to death. Except when I support it when it comes to me, right? So if somebody hurts or kills someone that I love, not only do I want the death penalty, like I want to do it myself, like, and I mean that. Like I would very much be, and I'd have to rethink my position on the death penalty. If I'm being honest here, I would love to be able to say, yeah, no, if they killed, somebody I care about so much, that I would still stick to my principles and say, no, they don't do, no, I might say, fucking, yeah, flip the switch on that motherfucker, right? Fry them. So I definitely understand the victim, the victim family, particularly, right? How they might feel when it comes to that. Still, the issue of death qualification causes a problem because we're ending up, if it's a death penalty case, you don't have any bleeding heart liberals who are opposing the death penalty. There are none of them on your jury. Like, all of those people that are on your jury support the death penalty. So you're gonna got some problems there, right? Okay, joking aside, I always use gallows humor. No pun intended. Gallows humor with these difficult decisions here. But some proposed reforms in terms of helping jurors make decisions. A number of judges have begun to allow jurors to ask questions during trial, or to take notes during trial. Also, this notion of reducing the size of juries from, instead of 12 jurors for criminal cases, to reduce that number down to 6 jurors. All of those have been put forward as ways to kind of help juries more easily reach adequate decisions. When it comes to the research, what the research shows about this in terms of note-taking, Penrod and colleagues, I say Penrod and colleagues, I worked with Penrod, Steve Penrod, at John Jay when I was an undergrad and when I was in grad school. But some of their research shows that notes probably are a minor memory aid, so they're not, they're not some panacea. They won't solve all of the problems when it comes to remembering things that have happened during the trial, but they serve some purpose. Also, note-taking does not increase juror satisfaction, so jurors are still meh about serving as jurors. So it doesn't increase their satisfaction with the trial, the judge, or the verdict. Jurors' notes do not produce a distorted view of the case, so doesn't seem to cause any harm in terms of what they're writing down, if they're only writing down certain parts of the case and not others. The notes tend to be fair, accurate depiction of the whole case. Note takers can keep pace with the trial, so doesn't seem to be a distraction to allow jurors to take notes. And jurors who take notes don't seem to distract other jurors, so it doesn't seem to be distracting to them, doesn't seem to be distracting to the jurors around them. Note takers do not have an undue influence over non-note takers, so when it's time to deliberate and everyone comes together to try to reach a verdict, nobody's going around saying, well, I took notes, so you need to listen to me, right? Nobody cares about you and your stupid notes, right? So they don't seem to have an undue influence. Jurors' notes tend to be accurate, as we said, and also seem to be fair. And note-taking doesn't seem to take up a whole lot of time. So the take-home message is that you probably don't, it's not going to cause any harm to have jurors take notes. If anything, it helps a little bit with memory, but there doesn't seem to be any harm in having jurors take notes. So more research should be done, particularly in real trials, so in the field, so to speak. In terms of jurors asking questions, so this is when jurors want some clarification about evidence, about testimony that's presented. What does the research show? Well, jury questioning promotes juror understanding of the facts and issues in the trial. Juror questions do not clearly help get to the truth. Juror questions do not alert trial counsel that a particular issue requires more extensive development. What does that mean? Well, it means that if a jury or a juror is asking a question about a particular issue, does that mean the defense says, oh shit, they're asking questions about this, we better make sure to pay more attention to that, or we better make sure we focus more of our energy on that issue? That doesn't seem to happen. Juror questions do not increase the jurors, judges, and lawyers' satisfaction with the trial, the judge, or the verdict. So it's not like questions are saying, asking questions, oh wow, this is great, trial was awesome for everybody. Not doing that. And although jurors do not know the rules of evidence, they tend to ask appropriate questions. So some take-homes just from this slide is that letting jurors ask questions helps them understand the facts and issues at trial. It doesn't necessarily help them get to the truth per se, and it doesn't seem to affect the case for anybody in terms of satisfaction. And jurors tend to ask appropriate questions. They're not asking some stupid, non-relevant questions. They seem to ask some pretty decent questions. Some additional findings when it comes to juror questions is that counsel is not reluctant to object to any inappropriate questions. This could be a concern because the last thing you want to do as a lawyer, right, for the prosecution or the defense, the last thing you want to do is piss off the jury or a juror, right? So concern was that, well, if a juror does ask a stupid question, the attorneys might be afraid to object because they don't want to piss off the jury or the jurors. That does not seem to happen. The attorneys don't seem to have any problem objecting to inappropriate questions. Also, if counsel does object to an inappropriate question and the objection is sustained, that the judge agrees with it, the jury does not draw any type of inappropriate inferences from the unanswered question. So that's another issue, right? So if a juror asks an inappropriate question and the counsel, a lawyer objects and the judge, agrees with the lawyer, you might say, well, if the judge agrees with me objecting, then maybe the jury thinks, or the juror thinks, a certain way about that question, because the judge doesn't want me to answer it, and the prosecution doesn't want me to answer it. So the defense, this question that I asked probably favors the defense, right? That is a concern, but the research shows they don't actually do that. Jurors don't actually draw those types of inferences about questions that were objected to and sustained. Also, jurors do not become advocates rather than neutrals, so they don't start formulating their questions as in ways to try to prove the defendant guilty or not guilty. Their questions just tend to be informational in nature. They're not biased or leading types of questions. So they just tend to be questions of clarification. Also, jurors do not overemphasize their own questions and answers at the expense of other evidence presented during the trial. So they don't say, well, my question, and it was answered this way, so that outweighs the testimony of that person, over there. They don't seem to do that. They don't seem to, put more weight on say, answers to their own questions, compared to other evidence that's in the trial. And it seems that juror questions don't seem to have a prejudicial effect. So allowing jurors to ask questions and having particular jurors ask questions don't seem to prejudice the other jurors in terms of reaching a verdict. So again, when it comes to juror questions, doesn't seem to be harmful in any way. Certainly looks like there's some benefits to it, but again, doesn't seem to be harmful. So more research would be needed, particularly in real trials. But people are very reluctant to try new things in real trials because we're talking about people's life and liberty in a real trial. So we probably shouldn't be fucking around with that in terms of doing experiments. So it's difficult to get real world type of data on this. But judges have been experimenting with this stuff, so we actually do have real world data. And when it comes to note taking and questioning, they don't seem to be magical in terms of helping jurors reach a decision, but they seem to be somewhat helpful, and most importantly, they don't seem to cause any harm in there. When it comes to jury size, a lot of people will advocate that a smaller jury is better because it's less people, less chefs in the kitchen, right, so to speak. That's saying more chefs in the kitchen, like more people with their opinions is gonna make for a more difficult decision-making process. That does not seem to be true, according to the research. So, just a couple of research findings. The punitive awards of 6-person juries were highly variable compared with 12-person juries. What does that mean? Well, there seems to be more agreement among a jury of 12 people compared to a jury of 6 people. So it's actually reducing the size of the jury is having the opposite effect of what people would claim, or advocates of this thought. You have more disagreement among 6 people than you do 12 people, right? Also, 12-person jurors tend to deliberate longer. They tend to recall more probative information, and they rely less than 6-person jurors on evaluative statements and non-probative evidence, right? So 12-person jurors are actually doing a better job at focusing on the evidence that they are instructed to focus on. And they actually spend more time talking about the evidence and deliberating about the evidence. So all research points to no for 6-person juries. 12-person jurors seem to do just fine in comparison to a 6-person jury, right? The whole idea of a jury system is up for debate in and of itself. But we have a constitutional right for it. Doesn't specify how many people have to be on a jury in the Constitution, but traditionally it's 12 for criminal cases, 6 for civil cases, and 12-person jurors tend to do better than 6. That's what the research shows. Okay, I think that's about it for jury decision making. That's the last slide here. So Next time, I believe we'll talk about some alternatives to traditional prosecution or traditional punishments. And then we'll start getting into information to prep us for the mock trial. Basically, courtroom procedures and things like that. Okay, so I will see you all next time. Take care.